Hello everybody, welcome to JURISCentral.com online classes for law exams. So today I will be discussing with you the previous year questions on Evidence Act for UPSC or Delhi APP exam, which is also conducted by UPSC and is scheduled to be held on 19th of September 2021. I have already shared the admit card link in the community page of my channel, so I would request you kindly go through that and download your admit card. So let us start. So first we will be dealing with the questions of 2017. Question number 1. Under which one of the following provisions of the Indian Evidence Act 1872 can the fact last seen become relevant? This is option number A, section 6, things forming part of same transaction. Question number 2. According to the provisions of the Indian Evidence Act 1872, which one of the following is correct under the rule facts not otherwise relevant become relevant? And also one more important thing, Evidence Act is very important for this exam, as you may expect around 40 questions from this chapter. So I would suggest you to go through the questions of Evidence Act. The correct option would be option number A, the plea of alibi, and it is given under section 11. Question number 3. A is accused before the court of session of attempting to murder a police officer whilst on his trial before B. The magistrate can be examined as to what happened in the court. The correct option is option number A. B may be examined as to what happened because it's a matter which occurred in his presence whilst he was so acting, and this has been given under section 121, which deals with judges and magistrates. Question number 4. When can an improper admission or rejection of evidence be ground on itself for a new trial or reversal of decision in any case? The correct option is option number B. If it appears to the court before which such objection is raised that there was inadequate evidence independently of the impugned evidence to have justified this decision. Question number 5. When can multiple dying declarations be relied under the Indian Evidence Act 1872? The correct option is option number A. Multiple dying declarations can be relied without corroborations if consistency is maintained by the witness throughout all declarations. Question number 6. Which one of the following is not included under secondary evidence? Is the option number C, oral account of a copy compared with the original given under section 63. Question number 7. The question whether X is the legitimate son of Z in view of the fact that X was always treated as such by the member of Z's family becomes relevant under which one of the following provisions of the Indian Evidence Act? So this has been given under section 50. Question number 8. Plea of alibi rule of evidence is recognized in which one of the following sections of the Indian Evidence Act? This is option number C, section 11. Question number 9. Which one of the following declarations is not correct with respect to the rule of res geste? This is option number C, must be independent facts previous or subsequent not relating to the transaction. Then question number 10. The best evidence rule excludes secondary evidence of documents if option number A, if originals are available. Question number 11. Fact and issue is defined under the Indian Evidence Act 1872 that includes any fact from which either by itself or in connection with other facts the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceedings necessarily follows. In a case where A is accused of murder, which one of the following fact is not a fact and issue? So the correct option is option number C, that A was too poor. Question number 12. Dying declaration under section 32 of the Indian Evidence Act 1872 is an exception to the rule of option number B, hearsay. Question number 13. Under the provisions of the Indian Evidence Act 1872, shall presume means it means option number D, presumption of facts as well as rebuttable presumption. Question number 14. Which one of the following is a presumption under section 112 of the Indian Evidence Act? This is option number B, legitimacy of a child. 15. Which one of the following statements with regard to dying declaration is not correct? This is option number C. A dying declaration given to a close relative shall be the sole evidence for conviction of the accused. Then question number 16. Section 113B of the Indian Evidence Act 1872 deals with option number C, presumption as to dowry death. Question number 17. Which one of the following statements about test identification parade is not correct? This option number A. TIP is a piece of substantive evidence. Question number 18. Which one of the following is not secondary evidence? Is option number D. A copy transcribed from a copy but not compared with the original. Then question number 19. Section 27 of the Indian Evidence Act 1872 permits the use of discovery evidence which lays down strictly as to how much of the information contained in the statement of the accused is made admissible. Which one of the following information is relevant under this section? So the correct option is option number D. Information given by the accused as relates distinctly to the fact thereby discovered. Then question number 20. A confession is admissible if it is made by the accused to option number A. Any metropolitan magistrate or a judicial magistrate while he is in the custody of a police station. Then question number 21. A witness who is unable to speak may give his evidence in any other manner in which he can make it intelligible as by writing or by signs, but such writing must be written and these signs made in open court. Evidence so given shall be deemed to be, this is known as option number C, oral evidence. Question, now we will be dealing with the questions of 2015. Then to question number 22. All evidences taken in the course of the trial or other proceedings must be taken in the presence of, this option number C, the accused or when his personal attendance is dispensed with in the presence of his pleader. This has been given under section 273 of CRPC. Question number 23. When a witness shall be compelled to answer a question is decided by the option number C, court. 24. Hostile witness is a witness who, option number C, gives evidence in favor of the opposite party. 25. Oral evidence given in a court, option number D, it must be direct. 26. Which one of the following evidences may not be admissible in a court of law? This is option number A, by a spouse as regards their communication. Then question number 27. Court for the purpose of Indian Evidence Act doesn't include, option number C, arbitrator. 28. The case of Sharat Chandra Dev versus Gopal Chandra Saha deals with option number D, estoppel. 29. Statement made in police custody by the accused amounts to confession when, option number A, that part of the statement which leads to the discovery of the object. 30. Oral admissions as to contents of electronic records are relevant when the genuineness of the option number 1, electronic record produced, is in question. Question number 31. No judge or magistrate can be compelled to answer any question as to his own conduct in court as such judge or magistrate except upon the special order of option number C, court to which he is subordinate. 32. Leading questions can be asked in option number D, cross-examination. Question number 33. Under section 113A of the Indian Evidence Act, in which one of the following circumstances the court may not presume abatement of suicide by a married woman by her husband or relative? This is option number C, when the married woman committed suicide after 10 years of her marriage, because the victim has to commit the suicide within 7 years of marriage to invoke the presumption under section 113A. 34. Presumption as to electronic record under Indian Evidence Act is drawn by the court when the record is, option number A, 5 years old. 35. According to the Indian Evidence Act, expert is a person who is especially skilled in, option number D, foreign law or science or art or handwriting or finger impressions. 36. According to the provisions of the Indian Evidence Act, a fact is said to be not proved when, option number C, it is neither proved nor disproved. 37. In criminal cases, which one of the following statement is correct? Option number A, that the fact that the accused is of a good character is relevant. 38. Which one of the following statement is not correct? This option number D, statement of dying declaration cannot be recorded by a police officer. 39. Which one of the following is not mentioned under section 14 of the Indian Evidence Act? This is option number D, conduct. 40. Which one of the following statement is not correct in relation to documentary evidence? This is option number D. A document must be proved by its primary evidence except where a party is entitled to give secondary evidence thereof. Then 41. The question of proving a document arises when its execution is denied by the adverse party. In such a case, a public document can be proved by option number A, by its certified copy under Section 77 of the Indian Evidence Act 1872. 42. Section 101 of the Indian Evidence Act 1872 states that whoever desires a court to give judgment as to any legal right or liability dependent on existence of facts which he asserts must prove the existence of that fact. This means that option number D, proving of a fact, means proving it beyond doubt. 43. The presumption of law under Section 111A of the Indian Evidence Act 1872 is not applicable where an offence has been committed, option number D, under Section 151, 146 and 153 of the Indian Penal Code, and it deals with joining unlawful assembly and riots and the offences relating to the riot. Question number 44. The case of Chilikuri Venkateshwarulu versus Venkata Narayana deals with option number C, proof of legitimacy. Question number 45. Secondary evidence doesn't mean option number D, document itself produced for the inspection of the court. Question number 46. Admissions according to the Indian Evidence Act 1872, option number D, can be proved by or on behalf of the person who makes them or his representative in interest. Question number 47. Section 112 of the Indian Evidence Act 1872 is based on the principle that law favors legitimacy rather than bastardity of children. It is conclusive presumption and can be reverted only on the ground of option number B by non-excess of parties. Now we'll deal with questions of 2010 Delhi Assistant Public Prosecutor exam. If an accused pleads guilty, the judge, option number D, has the discretion to convict him depending upon corroboration of evidence. Question number 46 49 under the Indian Evidence Act, which one of the following is correct? This is option number C. The judge has power to ask any questions to the parties witnesses on any fact relevant to the case. Question number 50. In cases where a document proved to be 30 years old is produced from proper custody, which of the following presumptions will the court make? This is option number C. The court may presume that the signature and handwriting is the signature and handwriting of the person to be and was duly executed and attested. 51. In which of the following circumstances the court will not allow oral agreement to be given in evidence for the purpose of varying, contradicting, adding to or subtracting from the terms of contract proved by production of the document as per the provisions of the Indian Evidence Act? This is option number D. When there is an oral agreement which seeks to clarify the terms of the contract that are unambiguous. So let me tell you, this question is based on section 92, in which it is said that suppose if there is any contract, grant or disposition of property documents which is already given in written, so on those against those documents no oral evidence can be preferred. Question number 52. A surgeon in good faith communicates to a patient his opinion that he cannot live. The patient dies in a consequence of the shock. A is guilty of option number D, no offence. 53. Which one of the following facts is not relevant under the Indian Evidence Act? This option number A. Where accused was charged for the murder of X, the fact that accused was in the habit of shooting at people. Question number 54. Which one of the following statement is correct with respect to admissibility and relevancy of evidence? This is option number A. An admissible fact is always a relevant fact. 55. Upon acquittal, a co-accused can be option number C, a witness for the prosecution as well as for the defense. 56. The doctrine of estoppel is applied, option number C, both in civil and criminal matters. 57. Under section 122 of the Indian Evidence Act 1872, immunity of privileged communications is available to option number D, only to husband and wife. Question number then we'll deal with questions of 2011 Delhi APP exam. 58. A witness may refresh his memory by referring to any writing made by this option number C, 1, 2 and 4 by him at the time of the transaction, then him soon afterwards, that the court considers the transaction fresh in his memory, and 4, any other person present at the time of transaction. Question number 59. The Indian Evidence Act doesn't deal with option number D, rejection of evidence. 60. The conduct of any party for the purpose of section 8 of the Indian Evidence Act doesn't include statements, option number C, unless a companion explain acts involved in those statements. So section 8 deals with motive, then conduct of the parties. 61. Cross-examination of witness. So you have to choose the correct answer using the codes given below. This is option number B, 2 and 3. Cross-examination need not be confined to the facts to which the witness testified on his examination in chief, and 3 must relate to the facts in issue in that proceedings. Then question number 62. When the Indian Evidence Act declares one fact to be conclusive proof of another, the court, option number D, shall on proof of the one fact regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. 63. In camera trial refers to option number C, trial to which public and press are not allowed. 64. Indian Evidence Act deals with option number 1 and 3 only, relevancy of evidence and admissibility of evidence. According to the Indian Evidence Act, a fact is said to be not proved when the option number C, fact is neither proved nor disproved. 66. Admission according to the Indian Evidence Act includes statements made by option number A, 1, 2, 3 and 4, expressly referred person, agent of a party to proceedings authorized to make the statement, then 3, person whose liability must be proved, and 4, person from whom the party derived his interest in the subject matter. Question number 67. Cross-examination of one's own witness is option number E, permissible only after obtaining the permission of the court. 68. Which one of the following is not relevant under the Indian Evidence Act? Option number A, previous judgment as to prove. Actually ignore this question because this question is actually wrong. 69. Cross-examination of one's own witness is option number B, permissible only after obtaining the permission of the court. 70. The Indian Evidence Act declares that anything said, done or written by any one of the conspirators is relevant to prove conspiracy if it was in option number A, pursuance of their common intention. 71. Photo fit, that is superimposed photograph of the deceased over the skeleton of a human body skull recovered from a tank to prove the fact that the skeleton was that of the deceased, was held to be admissible by the Supreme Court of India in the case of option number A, Ram Lochan versus State of West Bengal. 72. The plea can succeed only if it is shown that the accused was so far away at the relevant time that he couldn't be present at the place where the crime was committed. The Supreme Court of India in this observation was referring to the plea of option number C, alibi given under section 11. 73. Which one of the following statement is not correct according to the provisions of the Indian Evidence Act? This is option number C, where a document is executed in counterpart, each counterpart is primary evidence for the parties executing it. Then just a second. Primary. Yes, this is not correct. 74. Which one of the following statements according to the Indian Evidence Act is correct? This is option number C. All facts except the contents of document or electronic records may be proved by oral evidence. 75. According to the Indian Evidence Act, the burden of proof in a suit or proceeding lies on the person, this is option number C, who would fail if no evidence at all were given on either side. 76. Leading questions can be asked, option number 1, in cross-examination. Then question number 77. The question in cross-examination, option number B, need not be confined to the fact testified by the witness on his examination in chief. 78. Oral account of the contents of a document by a person who has seen it. It is actually option number C, secondary evidence. 17. And the confirmation of an additional judge of a high court as a permanent judge of that court without consultation with the collegiums of judges is option number A, invalid as held in S.P. Gupta's case. 80. Which one of the following statement is not correct? This is option number C. An additional judge of a high court cannot be confirmed as a permanent judge of the high court without consultation with the Chief Justice of India and a collegium of 4 senior most judges of the Supreme Court of India. 81. Indian Evidence Act doesn't apply to the option number 1 and 2, proceedings before the arbitrator, and 2, affidavit submitted by the deponent of his own. Then question number 82. Which one of the following is common in the provisions of section 123, section 126 and 127 of the Indian Evidence Act? So these 3 sections deal with privileged communication. The correct option is they are relevant but inadmissible. Question number 83. Which one of the following is not a primary evidence? Is option number B, a copy made from or compared with original. 84. According to the Indian Evidence Act, which one of the following statement is not correct? This option number B. When it is shown that one person stands to the other in a position of active confidence, the burden of proving the good faith of a transaction between them is on the party that deposed confidence in the other. Then question number 85. A and B make a contract in writing that B shall sell A house to be paid for on delivery. At the same time, they make an oral agreement that 3 months credit shall be given to A. Can evidence of this oral agreement be given in a court? The correct option is yes, by a third party only if is affected against A or B. Then question number 86. Which among the following is not a fact admitted? These option number B. Facts which the parties agree in writing to admit before the hearing. 87. According to the Indian Evidence Act, which one of the following is irrelevant? These option number C. Evidence of character to prove the imputed conduct in civil cases. 88. Which one of the following is relevant? This option number D. Admission made by a party who has not been expressly referred to be a party to their suit. 89. In which among the following cases the Supreme Court of India said that it is not an absolute rule of law that dying declaration must be corroborated by other evidence before it can be acted upon? This option number A. This has been held in the case of Sharat Birdhichand Sharda versus State of Maharashtra. 90. Which one of the following doesn't fall into the category of expert evidence? Is option number C. Opinion by narco-analyst about the conditions of mind. 91. In criminal proceedings, under which of the following situations the fact that the accused person has bad character is relevant? Is option number D. 1 and 3. But the character of the accused is in issue, and 3 to rebut prior evidence of good character. 92. The legal of conclusive presumption of legitimacy under section 112 of the Indian Evidence Act can only be rebutted by option number B, by non-excess of parties. 93. And now we will be dealing with questions of 2008. When can leading questions be asked under section 142 of the Indian Evidence Act? This is option number C. If objected by the adverse party in cross-examination. Then 94. Cross-examination under section 137 of the Evidence Act means which one of the following? Option number B. Examination of a witness by the adverse party. 95. What is the number of witnesses required for the proof of any fact in any case? This is option number D. No particular number. There is no fixed particular number of witnesses that can be examined in a case. 96. Which of the following statement is or are not true? The correct option is option number C. 1 only. An accomplice is a competent witness against an accused person. Then question number 97. Which one of the following statement is not true? Option number B. Without the professional communication between an advocate and his client can be disclosed before the court without the consent of the client. This is not true. Then question number 98. What is the evidentiary value of evidence given by husband against wife and vice versa under the Indian Evidence Act 1872? This is option number D. Evidence can be adduced by both civil and criminal proceedings. Question number 99. Who among the following is competent to adduce evidence under Indian Evidence Act? This is option number A. Dumb witness. Question number 100. Under which section of the Indian Evidence Act the presumption as to abatement of suicide by a married woman is still? This is option number A. Section 113A. 101. The court draws a presumption of legitimacy when any person is born during the continuance of a valid marriage between his mother and any man. This presumption is relevant under section 112 of the Evidence Act when there is a dispute relating to the option number B, paternity of the child. 102. The Indian Evidence Act 1872 applies to option number B, all judicial proceedings in or before any court. 103. Burden of proof under section 101 of the Evidence Act, option number A, it never shifts. 104. In order to raise a presumption in favor of an electronic produced before a court from any proper custody, the record must be minimum of option number A. It must be minimum of 5 years old. 105. Which one of the following facts need not be proved? Option number C. Facts taken judicial notice by court. 106. Which one of the following statement is not correct? Option number B. In criminal cases, previous good character is irrelevant. Well, this is not correct. Question number 107. Which one of the following is not a correct statement about expert opinion? Option number C. Expert opinion is binding on the judge always. 108. Which of the following is not a secondary evidence? Option number D. Oral accounts of the contents of a document given by some person who has himself not seen it. Then question number 109. Under which of the following situations secondary evidence of a document under section 65 of the Evidence Act is not permissible? This is option number D. When the evidence of the original has been proved to be admitted orally by the person against whom it is proved. 110. Consider the following statements. Option number A. In criminal proceedings, a burden of proof is option number 1 on the prosecution to prove the guilt of the accused person. 111. Which one of the following statement is not correct? Refresh memory by a witness under section 159 of the Evidence Act means option number D. Referring to another witness for taking his evidence when this is not correct. 112. A is accused before a court of sessions of attempting to murder a police officer whilst on his trial before B. A sessions judge can be examined as a witness under the above situation as to what has occurred in his presence. This option number A may be examined as to what occurred. Question number 113. Match list 1 with list 2 and select the correct answer using the codes given below. So let us match the examination of a witness by the party who calls him. It is known as option number 2 examination in chief. Witness who lets down the party who calls him. This is option number 3 hostile witness. Examination of a witness by adverse party is called cross examination, and this question suggesting the answer which the person putting it wishes or expects to receive, not deceive, it is receive, and this is known as leading questions. Then question number 114. A is tried for the murder of B. He takes a plea of self-defense, but the evidence adduced by him is not sufficient to put his case under the exception, although it is enough to create doubt whether the charge against him has been positively proved. In this case, the correct option is option number D. A is entitled to acquittal as the prosecution has failed to prove this guilt beyond reasonable doubt. 115. The following 5 items consist of 2. Actually, this is a question based on assertion and reason. I have only chosen the question of Evidence Act. Assertion: a confession made to a police officer is not admissible. Reason: the intention of the legislature is to put stop to the extortion of confessions from accused persons. The correct option is option number A. Both A and R are individually true, and R is the correct explanation of A. 116. Facts under the Evidence Act means option number D. Anything capable of being perceived by the senses and any mental condition of which any person is conscious. 117. Which one of the following statement is not correct? Option number D. The court takes the assistance of expert when it has to form opinion on point of Indian law. No, because it takes the assistance of expert when it has to form an opinion on point of a foreign law. 118. In which one of the following a dying declaration is admissible? Option number C. Both in civil and criminal proceedings. 119. Which one of the following statement is true? Admissions are option number B. Not conclusive proof of the matter, but may operate as estoppels under certain provisions of the Evidence Act. 120. Under which condition a court may take into consideration the confession of one accused against himself and another person? Option number A. If they tried jointly for the same offence. 121. Oral evidence under section 60 of the Evidence Act 1872 must in all cases be option number C. Direct. 122. Section 27 of the Evidence Act applies option number B when the person giving information is an accused and is in police custody. 123. The term police custody used under section 26 of the Indian Evidence Act 1872 means which one of the following? Option number D. Some kind of surveillance and restrictions over the accused person by the police. 124. Which of the following statement is correct? Option number A. Admissions may be oral or documentary or contained in an electronic form. 125. Which of the following statement is true? A is tried for the murder of B. There is evidence of the fact that B prosecuted A for libel, not libel, it's libel, and that A was convicted and sentenced. This judgment is option number D, relevant under section 8 as showing the motive for the murder of B. It is given under section 43. Which one of the following statement is not true? This is option number D. According to section 5 of the Evidence Act, evidence may be given in any suit or proceedings of the option number D, those facts which the party thinks are relevant. Question number, now we'll deal with the questions of 2005 Delhi APP exam. 197. Which one of the following statement is respect of admissibility and relevancy is correct? Option number A. An admissible fact is always a relevant fact. 128. Which one of the following statement is correct? Option number D. Evidence to support or to rebut any fact before the court in criminal proceedings. 129. Which one of the following statement is correct? The alibi under section 11 of the Indian Evidence Act 1872 is decided on the basis of option number D. Preponderance of higher probability or improbability as well beyond reasonable doubt. 130. Which one of the following statement is correct? Admission is acknowledging any right of liability under civil law made, option number D, by conduct orally or in writing or contained in electronic form. 131. What does police custody in the context of the Indian Evidence Act 1972 means? Option number D, some kind of surveillance and restriction by the police. 132. Which one of the following statement is correct? Option number D, Section 158 of the Indian Evidence Act. A dying declaration made under Section 32 of the Indian Evidence Act is subject to the control of option number D, Section 158 of the Indian Evidence Act. 133. Which one of the following statement is correct? Option number D. A public document is a document which was executed by a public servant in public capacity. 134. For which of the following documents oral evidence cannot be given to remove any ambiguity? This is option number D. A will to which Indian Succession Act 1925 applies. Then question number 135. A court cannot compel the parties to undergo a blood test to establish the legitimacy of the child because it would amount to declaring the mother as unchaste and child as illegitimate. This view was laid down in which one of the following cases? Option number C, Ningamba versus Chikia. Then question number 136. Which one of the following statement is correct? The protection of professional communication as provided under Indian Evidence Act 1872 in section 126 to 129 is available only. Option number D, after commission of the crime or illegal acts. 137. Which one of the following statement is correct? In a trial of A for the murder of B, marks on the ground produced by a struggle at or near the place of murder is a fact. Option number D, as to the occasion, cause or effect of vaccination. 138. Match list 1 with list 1. Select the correct answer using the codes given below the list. This is correct option is option number A. Noor Muhammad versus Imtiaz Ahmad is a case relating to section 6 of the Indian Evidence Act. Pratap Singh versus State of Punjab is a case relating to section 7 of the Indian Evidence Act. Shardul Singh versus State of Bombay is a case relating to section 8 of the Indian Evidence Act. Raghunath versus the Indian Evidence Act. Raghunath versus the state is a case relating to section 17 of the Indian Evidence Act. Then question number 139. Which one of the following statement is correct? A struck B on the neck with a knife and this was seen by C, who exclaimed, A is killing B. C's examination is option number B, relevant because it forms part of the transaction. 140. Match list 1 with list 1. Select the correct answer using the codes given below the list. So let us match. Presumption as to books, map and charts. This has been given under section 87 of the Indian Evidence Act. Presumption as to power of attorney. This has been given under section 85 of the Indian Evidence Act. Then a presumption as telephonic messages. This has been given under section 88 of the Indian Evidence Act, and presumption as to plans made by authority of government is given under section 83 of the Indian Evidence Act. Then question number 141. Which of the following pair is not correctly matched? The correct option is option number C. Section 21 of the Indian Evidence Act, admission by person expressly. Actually, in my view, this question is actually incorrect. The answer is actually incorrect. So just ignore it. 142. Which one of the following statement is correct? Option number C. A who has taken vow of silence gives evidence in writing in open court. His evidence shall be deemed to be oral evidence. 143. Consider the following statements. So this option number C, 4 only. Privilege granted to lawyers under section 126 aims at the protection of lawyers. Which of the given statement are true? Yes, this is the correct option. Then question number 144. A is indicted for the murder of B. C says that B, when dying, declared that A had given B the wound of which B died. Evidence is offered to show that on a previous occasion C said that the wound was not given by A. The correct option is option number B, admissible under section 154 of the Indian Evidence Act. Question number 145. Consider the following statements. The correct option is option number C, 1 and 4. In criminal proceedings, good character of the accused is always relevant, and 4. Previous conviction is relevant as evidence of bad character. 146. Consider the following statement. The Indian Evidence Act is applicable to option number D, 1 and 4. The proceedings under Chapter 9 of CRPC, which deals with maintenance of wives, parents and children, and 4. And execution proceedings. 147. Which one of the following doesn't fall within the meaning of the term court used under Indian Evidence Act 1872? This is option number D, Enquiry Commission, Legal Advisor and Excise Officer. 148. Facts not otherwise relevant are irrelevant if they are inconsistent with any facts in issue or relevant fact. This is option number C, section 11. Facts not otherwise relevant are relevant. Question number 149. Which of the following statement is correct? Option number C, a dying declaration is substantive evidence. 150. Which of the following statement is correct? Option number B, section 91 of the Indian Evidence Act doesn't apply to criminal cases. It only applies to contracts, grants or documents as to disposition of property. 151. Which of the following facts can be proved under section 92 of the Indian Evidence Act? This is option number D. A enters into a written contract with B to work in certain means the property of B or on certain terms. A says that he was induced to do so by misrepresentation of B as to their value. So this illustration has been given under section 92 of the Indian Evidence Act. 152. Which of the following observation is correct? Option number B, where section 91 doesn't apply, section 92 also doesn't apply. Both these sections are actually dependent on each other. 153. Which of the following statement is correct? Option number C. A representation made by an agent is effectual for the purpose of estoppel if it had been made by his principal. Question number 154. Which one of the following facts is protected from disclosure in a court of law? This is option number A. A client says to be an attorney, I have committed forgery and I wish you to defend me. So this is one of the facts which is protected from disclosure in a court of law. 155. An accomplice shall be a competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice, and this has been given under section 133 of Evidence Act. 156. In which of the following circumstances are there no reasonable grounds for putting the question to the witness? Option number C. A witness of whom nothing whatever is known is asked at random whether he is a dacoit. 157. Which of the following statement is correct? Option number B. Leading question may be freely asked in cross-examination. 158. Which of the following pieces of evidence is not relevant under the Indian Evidence Act? This is option number C. A custom officer gives evidence that the accused B made a confession of his crime to him. It is not a piece of evidence relevant under the Indian Evidence Act. Then question number 159. Which of the following pieces of evidence is not relevant under the Indian Evidence Act? Option number D. A is tried for the murder of B by intentionally shooting him dead. Evidence is given that A was in the habit of shooting at people with intent to murder them. It is not relevant in the present case as to the murder of B. 160. Which of the following statement is correct? Option number B. The Indian Evidence Act applies to a proceedings whose object is to determine a juror relation between one person and another. 161. Consider the following statement. Option number D, 1 and 3. The proceedings of the Parliament or state legislatures of India are judicially noticeable facts. 3. Criminal law in force in India is judicially noticeable fact. So this is the question. These are the questions which I have dealt with you today, and there are total number of 161 questions, and these questions have been asked in the UPSC CBI exam as well as the Delhi APP exam, and these questions are very, very important for your upcoming UPSC prosecutor exam. So with this note, I am signing off. Have a great day.